Poloff?
Hello.
Hey, how you doing?
Hi, members of the committee. Yes, my name is Stephen Poloff. I'm an attorney here in Connecticut, based in New Haven. I'm not appearing on behalf of anyone but myself. I just thought, I'd give some perspective on SB 1442. I've practiced before the CHRO. I'm familiar with its procedures. I submitted testimony just discussing some of my thoughts on how some of these procedural questions that the bill attempts to address might better be answered. But I did actually, I won't just read from my testimony. I wanted to offer some thoughts on this, purported expansion of individual liability. I think what is being missed here from the conversation is that this is not just and just to clarify, I do management side advice and counsel. I represent employers. I don't take plaintiffs' cases. And what this represents is a significant expansion of not just liability, but also jurisdiction of the CHRO. And I'll give an example. Uh, Connecticut follows, and this statute proposes agency language. Connecticut follows the scope of employment test. To qualify as an agent, and when I say expansion of liability, I'm going with what the CHRO said that their intention is here. We're talking vicarious liability. If an employee acts in the furtherance of an employer, their vicarious liability can attach. But that's a necessary component. If that's missing, then there cannot be liability for the employer, and that'll usually be in situations where you have an intentional tort, say sexual harassment. If the conduct that the tortious conduct had nothing to do with the employment, that's the kind of suit that wouldn't even go to the CHRO or right to Superior Court or maybe federal court, but typically Superior Court, and that's how it would be adjudicated. Under the CHRO, to take this very specific and very broad definition of what agency means in the employment context, that's the kind of complaint that could end up before the CHRO. And now, does the employee need to exhaust their administrative remedies? Must it be taken to the CHRO? There's a lot of questions here about, how that would sort of interact with existing law. I know that, a recent state Supreme Court decision was mentioned, but agency has long been understood under common law. Here and there, there's statutes discussing agency, but that test really has been a touchstone. And I'm a little concerned about some of this language, and I'm offering just general commentary about how this language would alter that. I appreciate the CHRO testifying, well, we've always done it this way. When you're changing the statute, you're expanding the power of an agency. I think we really need to consider the long-term impact of it, not just what a particular executive director or their staff might interpret it as such. So that is my commentary and
Questions from
testimony.
the committee?
Thank you.
Question. I'll dig in just briefly on this. So I'm trying to understand because, like I said, I've read the bill, I've read the Supreme Court decision, which I would note is a 4-3 decision. So oftentimes on 4-3 decisions, this committee is asked to, particularly where there's a written dissent that sort of suggests that there needs to be legislative clarity on the issue, that those are often the type of issues that get to this committee where there's a 4-3 decision and we're asked to provide clarity, right? And so I'm trying to figure out, we've got testimony from the CHRO saying the bill that they've offered before us is essentially a codification of the practice and provides that clarity with respect to their agency based on the decision. I look at this as, if you're talking about vicarious liability, I mean, of course, if a supervisor is discriminating against someone, that ends up leading to vicarious liability for the employing business, right? I mean, that's existing law. That if it doesn't need to be the owner of the business who discriminates, that if the supervisor is the one discriminating against someone, that ends up in financial liability for the business, correct?
Well, I'd say it's fact specific. Sure. I mean, just as a boilerplate, that's usually the kind of circumstance that would lead to liability, particularly if they are threatening some sort of adverse employment action. I mean, that's really the key. But and when we're talking discrimination, that can take a lot of different forms. I mentioned I've actually worked on a case that's would probably fall within the ambit of this language. Sexual harassment, is that discriminatory? And it can be in certain circumstances. Sexual harassment is usually, in many cases, if it's so overt, it's so clearly not within the scope of employment, it would not lead to liability necessarily. These are always fact-specific determinations, but it would not necessarily lead to liability for the employer. And,
Right.
that's sometimes appropriate. But to answer your question,
Right. So
I hope that's helpful.
right. So under existing law, the existing statute says it shall be discriminatory practice for an employer, right? Or his or her agent. And there's a fact-specific inquiry under current law as to what constitutes the employer's agent or what does not constitute the employer's agent, right? Here, we're removing that ambiguity. What you're doing is you're making clear that the employer's agent is one who can either undertake or recommend tangible employment decisions affecting the employer or direct the employee's daily work activities. I mean, there's a way in which you could argue that this language actually narrows the definition of agency. Do you see that?
I see the language. I wouldn't agree. I think I would agree with it that it makes it clear. I think what it does is it clearly expands it in a very broad way, and I do worry that this could actually, I tried to provide an example of a case I've seen go to litigation, but I think this could be interpreted in ways the legislature might not expect. And what I would encourage is maybe to, if we're going to include something, a specific definition of agency in the discrimination context, maybe borrow a little bit more from the agency tests, really, particularly scope of employment, make sure that this test, and maybe it wouldn't be applied this way, but I think it's an open question, make sure that this test really captures that activity that is taken within the scope of employment and it not just a situation where there's tortious conduct by someone who happens to be a supervisor that, they know this employer doesn't approve of. And nonetheless, the employer perhaps doesn't even know about it. But since the supervisor now becomes essentially the employer is nonetheless liable for something that they never knew occurred, that they absolutely didn't approve of. Under existing law, that there wouldn't necessarily be liability for the employer. And I think that this would be an expansion of that vicarious liability, where the employer would have less room to make that argument. Hopefully that's helpful for your question.
Yeah, I get it, but I mean, I guess we
Okay.
have I guess we have that all the time. I mean, you've got take any major national company, IBM. I mean, you know, how do they ever know that somebody in one office, one place in the country is discriminating against an employee or sexually harassing? But the claim is always brought against IBM corporate as the parent, right? And I think here what we're doing, and again, not to argue with you, but I'm trying to understand what the concern is. I know that there was somebody sent me earlier today a blog post or something but I'm trying to figure out sort of where in the language the actual concern is, because I just I I think um so what you're saying is, I think what I'm hearing you saying is it needs to be clear that the discrimination needs to be in the workplace, as opposed to if somebody's employer discriminates against them, at the Little League field on the weekend type of deal. Is that what you're saying?
Sure. I mean, yeah, that could be one example, but it could be physically in the workplace. And, and this may be a policy disagreement. I might just be arguing a point that you or the legislature, as a matter of policy, thinks, well, we don't like that. And, and that's legitimate. That would be, then the legislature could make that change. But the reason I'm encouraging caution is because I do think that there's going to be some unintended consequences. And sure, right, maybe at the Little League game, there's some kind of harassment, could be sex-based, could be discriminatory. but the employer has no idea about it, doesn't approve of it, has nothing to do with it, and nonetheless, this person now, well, gee, they could make a recommendation about their employment. They've given them some day-to-day instruction. They are the employer. Now the employer is liable. And I think you could probably come up with a lot of circumstances where, I think based on the example you gave, you might be even uncomfortable with the idea of liability attaching. I think that's the risk of expanding vicarious liability in such a manner where I think we could use a few more elements here. And that would just be my point about the law. I think it would certainly, I think, could be construed as an expansion of existing law for vicarious liability. I don't agree with the CHRO's testimony that, oh, well, this is just how we've always applied it. I could see this applying to other circumstances that might be unexpected.
Okay, fair enough. Further questions or concerns? Seeing none, thanks for taking the time.
Thanks.
Dominic,